Court is calling 2018-292, 2016-56. Case 2016-56, Mr. Mills is for arraignment on the revocation petition which was filed July 5th of 2018. In it, it's alleged that he has violated terms and conditions of probation by committing a new offense of possession of a controlled substance. It's a felony offense, and he's also it's also a violation of a different term in addition to the not violating the law, but to be in probation and in possession of controlled substances. That was one of the conditions against it. In case 2018-292, the charges against him are, as indicated, possession of a controlled substance, methamphetamine or cocaine, Schedule 1 or 2, Class D felony. Now, in each of these cases, how does the defendant now plead?
Judge, for today, I've told Mr. Mills that he needs to fill out an application, but that we would stand in for his arraignment and pleas today and request a bond. For now, we will enter a plea of not guilty on his behalf, pending that paperwork being turned in.
Mr. Mills, the court's noting a plea of not guilty in case 2018-292 and not true in case 2016-56. You are ordered by the court, if you're going to seek the public defender's office, to fill out the application and get it done today. The applications are there at the jail. You need to fill out one that covers both those separate charges, not just one of the charges. If you're going to be represented by them. Court, in case 2018-292, is setting you down by scheduling order for a trial the week of February 25th, a plea deadline date of February 21st, a pretrial date of January 24th, and a reappearance date of November 15th. All of those dates will be in a scheduling order, and you'll be ordered to appear. The court is setting your bond at $2,500, and that'll be a bond that covers both of these, both the new charges and the revocation. In the revocation case, I'm ordering you to reappear on August 2nd to face revocation on those charges. That'll be, we'll take the revocation issue up on August 2nd. In the meantime, you'll need to get your application in, get appointed to the public defender's office. If you make that bond, it is your obligation to first of all be in court on August 2nd, and then all the other, in the other case, all the court-ordered appearances that are listed that I listed off earlier. The next one for checking on the status of the case is November 15th. But it's your obligation to be there. If you fail to show up, a warrant will be issued and you'll be back in jail. Now,
Yes.
The court is also going to advise you that you're also under an obligation, if you bond out, to get in and report to the to your attorney immediately. What I mean by that is that as soon as you get out of jail, you need to call up the public defender's office, schedule an appointment, and get in to see the public defender's office. Because August 2nd is coming up very rapidly. It's 3 weeks away, I think. And so you'll need to be in touch with them and making arrangements to get in to see them, because they're not going to be prepared to take up your case and represent you unless you get in to see them. So if you make that bond, it is your obligation, and I'm ordering you to get in to see them. Failure to do so, the court will consider to be contempt of court, and you could face further incarceration. So just understand, that's an obligation on you, and I'm ordering you to get in to see your public defender. Now,
Yes, sir.
finally, if you don't make bond, of course, you'll be there and available, and I'll expect the public defender's office will come over and see you over there. So, yes.
Your Honor, the probation and parole would like to ask that he also be ordered to appear at probation and parole if he does make bond, and then also that he be drug tested weekly.
Yes. That'll be an order of the court, that if you get out on bond, you need to get in to see your probation officer as you were required to do by probation before. So that's a requirement. You need to, as soon as you get out of bed, you're ordered to report to probation within 24 hours, and you'll be subject to weekly drug testing until as we proceed on this case. All
Yes,
right,
sir.
you may be excused, sir. Court calls 2018-293 State of Arkansas versus Tyler Wheeler.
Judge, I met with Mr. Wheeler at the jail. We've represented him previously. He indicated that he would be filling out an application if he hasn't already. I told him we could represent him for his arraignment, in which will plead not guilty to the charges and take up any issues of bond.
The charges that the defendant is facing is possession of a controlled substance, Schedule 3, that's a Class D felony. On those charges, how's the defendant now pleading?
Not guilty.
Plea of not guilty is noted. Court is directing you to meet. He'll be back in, he'll appear before Judge Putman on July 26th to get on Judge Putman's scheduling order.
Judge, with regard to bond, I don't think it's an issue at this time. He's got a parole hold that has not been lifted. It has been lifted, okay. So if the court would issue a bond for him,
Now, there was a bond on Mr. Wheeler's set time of his arrest.
I'm sure that's
$2,000.
appropriate, Your Honor. We're not gonna object to that.
State.
All right. That's the bond.
Thank you, Your Honor.
Now, again, Mr. Wheeler, you'll be excused. You need to, if you're released on bond, that bond, you need to understand that you have an obligation to be in court a week from today, or no, it's 2 weeks from today, in front of Judge Putman. That's on July 26th, when he'll be in the courtroom I'm sitting in today. He'll be here, and you need to appear before him to get on his scheduling order. And you also have an obligation to report in accordance with whatever parole obligations you have. So you're not just free to get out on bond and go about your business. You still have obligations. All right. You may be excused. 2018-294, State of Arkansas versus Patricia Wheeler.
Judge, I did talk with Patricia last night at the jail as well, indicated that she needed to fill out an application. She does want to request our services. Told her we'd represent her today for arraignment purposes, and she'd get that paperwork filled out.
All right. Wheeler's appearing today on charges of possession of a controlled substance, Schedule 3, that's a Class C felony, and driving on a suspended license, it's a misdemeanor. On those two charges, how does Ms. Wheeler plead?
Not guilty, Your Honor.
Ms. Wheeler, the Public Defender's Office is appearing with you today and entering your plea of not guilty. You need to fill out that application and get it turned in today. Now, the court is taking your plea of not guilty and noting it on the record. The court is entering a scheduling order. It will set you for a next appearance in circuit court is November 15th. That's to check on the status of the case. On January 24th of 2019, you have a pretrial hearing scheduled. On February 21st, you have a plea deadline scheduled. And on the week of February 25th of 2019, that week you're scheduled for trial. In any case, apparently the bond was set in your case is $2,000.
I thought the bond was $5,000.
For some reason, the jail thinks it's $5,000, Your Honor, but I think as long as the court issues its order that it is actually $2,000.
It's 2,000 on all our paperwork, Your Honor.
It originally, in the original prepared affidavit signed by Judge Putman, the bond was listed as it's either $5,000 or $6,000, but Judge Putman interlineated and set it at $2,000. So that'll be the bond.
Thank you, Your Honor.
Now, Ms. Wheeler, if you get out on bond, that bond, again, I remind you, you have an obligation as soon as you get out to make contact with and stay in touch with the Public Defender's Office. It's not their responsibility to get hold of you, it's your responsibility to get hold with them. So I'm ordering you, as soon as you get out of jail, you contact the Public Defender's Office, schedule an appointment, and get in to see the Public Defender, and keep your appointment. If you fail to do so, and we come up on those later dates and you've not contacted them, I'm going to hold you in contempt of court, because I'm telling you right here in court that you're ordered to get in touch with them. So see about that, all right?
Sir.
You may be excused at this time. (2018-295) State of Arkansas versus Travis Langston.
Judge, I met with Mr. Langston at the jail last night. Again, he indicated that he will need the services of a public defender. I told him to fill out the forms for us and that we would enter a not guilty plea for him today.
All right. On the charges in this matter, Mr. Langston is charged with possession of controlled substance, Schedule 1 or 2, Class D felony, possession of drug paraphernalia, Class D felony, a second count of Class D felony, possession of drug paraphernalia, simultaneous possession of drugs and firearm, a Class Y felony, and possession of a firearm by a certain person, a Class D felony. On those charges, how does Mr. Langston now plead?
Not guilty. Judges, I believe there's a parole hold at this time, so bond won't be an issue. There is a bond set in case that hold is lifted that he could make.
That's what I was looking for. You know what the amount is that's set?
I think the jail is understanding is that it's $15,000 cash or surety. But with that hold, he's not able to do that until that's resolved.
Maybe there's an 8.1. Yes, apparently it was a $15,000. Mr. Langston, the court's noted your plea of not guilty. The court advises you to reappear in front of Judge Putman on July 26th to get on his scheduling order. That's who your case is assigned to. You may be excused at this time. All right, I'll call 2018-298 State of Arkansas versus Gregory Smith.
Judge, I currently represent Mr. Smith in a matter pending in Division 3. If we could have Mr. Smith brought over today, I'm hoping that we can resolve these matters today.
Very good. All right, I'll go ahead then. Mr. Smith, have you made application to the Public Defender's Office?
No, I will.
Huh?
No, I will.
Get an application and bring it with you when you come over this afternoon. On the charges in this case of this new case against you, possession of controlled substance, Class D felony, possession of drug paraphernalia, separate Class D felony. How do you now plead?
Not guilty, Your Honor.
Plea of not guilty is noted. We'll go no further on this case, and we'll direct the defendant is to reappear this afternoon in court. You may be excused now. 2018-297, State of Arkansas versus Christian Manley. Ms. Manley, are you appearing, you're appearing at this time on charges of furnishing of prohibited articles in jail, that's a Class C felony, and possession of drug paraphernalia, Class A misdemeanor. On those, have you made any arrangements to be represented by an attorney?
Judge, I have spoken with her at the jail last night, and she understands that she needs to fill out the application, and I told her we'd help her for today's purposes.
All right. On those charges, how did the defendant now plead?
Not guilty, Your Honor.
That plea of not guilty is noted on the record. The case is assigned to the Division III docket of Judge Putman. I'm ordering her to reappear in front of Judge Putman on July 26th. Ms. Manley, it's your obligation to fill out that application if you want the representation of the Public Defender's Office. The applications are there at the jail. All you have to do is fill it out and then turn it in, and the appointment, formal appointment will continue on that. In the meantime, your next court appearance is July 26th.
Do I
Any
have
other-
a bond still?
Judge, Christian, we have an agreement on bond, and I'm gonna talk with the prosecutor and the judge about that at the break, okay? And we'll let the jail know, okay?
All right,
Yes, sir, thank you.
Thank
you
you.
may be excused. All right, this is a, I'll have Brian Austin Baker, please. Mr. Baker, you're appearing before me for what's called a Rule 8.1 hearing. Rule 8.1 refers to Rule 8.1 of the Arkansas Rules of Criminal Procedure, and it's a rule that's designed to ensure that somebody who's taken into custody and being held and then is unable to make bond is immediately comes before a judge. So what the rule requires is that you be brought before the judge as soon as possible after your arrest, and that you be advised by the judge of why you're being held and any bond or bonds that have been set in your cases. The court will also, as a part of the Rule 8.1, inform you of certain rights that you have while here. Frankly, looking over these documents, it's a little confusing to the court just exactly why you're being held. Not that there's any doubt that you should be held, it's just that there are so many different charges that apparently you're being held on. The court is reviewing documents. First of all, you were ordered to appear here today by an order of Judge Putman in order for the judge to be able to conduct this 8.1 hearing. So that's one reason that you're here today. Apparently, Baxter County District Court, you were found in contempt of court and failed to appear and failed to make the payment that on the fines that you had agreed to make. It appears that there is a $1,000 on that set of allegations. There's a $1,000 cash-only bond set out of District Court of Baxter County.
Yes, sir.
Now, there's a separate warrant of arrest, and again, a $1,000 cash-only bond in relation to another set of allegations here. And then there's a third warrant issued, and it's a little difficult for the court to tell whether there isn't a fourth set of such charges.
Yes, sir.
Mr. Etheridge, when is the next session of district court at which Mr. Baker could appear?
It would appear, Your Honor, would be next Thursday, Your Honor.
That's
The 19th.
that'll be the 19th.
Yes, sir.
court's gonna order, Mr. Baker to, if he makes the $1,000 cash-only bond that's imposed in this matter, the court's gonna direct that you need to understand that you have a responsibility to be in district court. That's not the court I preside over, it's the one that's basically a courtroom over in this same building, in the judicial building here in Mountain Home. And you need to be there.
Is there any way that my friend could pay part of my fines to make it a pro bond?
I said it's a cash-only bond set by the court. I'm not gonna change that. No, you need to get in there. If, you need to get in and appear in court. And then you wouldn't have cash-only bonds set on you. You know, that's really the only mechanism the court has to get you to make these kind of payments. You made an agreement to pay certain amounts and to appear in court and all of that, and by non-complying, the court essentially, when you don't show up, the court loses control. That's why they've set a cash-only bond. You have to pay $1,000 to get out of jail on this matter, and
Yes.
and after you pay that $1,000, you still need to be in court on Thursday, July 19th. All right?
Yes, sir.
Now, while you're incarcerated, you have certain constitutional rights. Those constitutional rights include the following: your right to remain silent. You have the right. That means you have the right to remain silent, which gives you the authority to tell a law enforcement officer who tries to interview you about your criminal activity that you do not wish to answer questions. It's just a right you have, and so that's what that means. You also have the right to an attorney. If you want to be represented by an attorney, you have the right to an attorney, and what that means is you have the right to go out and hire the attorney of your choice. Court does not get involved in that situation because that's a matter of private contract between you and the attorney you choose to hire. However, if in the process of trying to hire counsel, you discover you cannot afford to hire counsel, then the court would advise you that you still have the right to an attorney, and if you want to seek an attorney when you can't afford one, then you exercise your right to an attorney by making an application to the public defender's office. Those applications are there at the jail. You fill one out and turn it in, and it will get before a judge, and the judge will make a determination based on what's in the application whether to appoint you an attorney. And that's the way you secure an attorney if you cannot afford to hire one. Do you have any questions about these rights?
No, sir, but can I make a note of something?
Well, all right, if you want to make a note, please tell me.
I was just wanting to let you know that they had me sleeping on a mat on the floor in here. It's only like ½ an inch thick. And they haven't given me a towel yet since Monday, and that's when I got arrested. And I haven't been able to shower or anything, and I have no toilet paper. And I asked my girlfriend if she could look it up for me, that they said that the mats aren't supposed to be on the floor.
Well, I'm aware that when there is overcrowding in the jail, that the jail has to make certain arrangements. So you know, I understand what you're saying. Duly noted. It's the sheriff's responsibility to run the jail, and I'm not the sheriff, so I'm not going to participate in taking any action. I'm sure the sheriff is doing the best job that can be done. You wouldn't be in jail if you had taken care of your responsibilities.
Yes,
Let's
sir.
remember that. All right. You may be excused at this time.
Thank you, sir.